Hello, aspirants! Welcome to today's Explainer. We've got a crucial one for you today, diving right into a landmark judicial intervention that is going to be absolutely central for your General Studies Paper 2 syllabus. We're talking social justice, fundamental rights, and the judiciary. It's a case that really pushes the boundaries of state intervention and personal liberty. Let's get right into it.
Right, and here's the big question we're tackling today. Can a state medical board actually override a minor rape survivor's right to choose? This is the core of our explainer. It's this massive clash between institutional control, represented by state medical boards, and the sheer individual autonomy of a citizen.
Section 1. The Supreme Court Context.
Now, for your mains answers, you can't just throw around abstract concepts, right? You need the hard facts, the exact context that forced the highest court of the land to step in. And the facts here are stark. We're looking at a 15-year-old rape survivor carrying a 30-week pregnancy. Usually, a 30-week pregnancy crosses standard statutory limits, no question. But the Supreme Court intervened and allowed the termination. And this specific ruling sets the stage for a really profound legal debate.
Section 2. Autonomy versus medical boards.
Aspirants, please mark this tension in your notes because it is a classic GS2 theme. It's that friction between the paternalistic control of state institutions and the constitutionally guaranteed autonomy of the citizen. Let's look at both sides objectively. On one side, we had Additional Solicitor General Aishwarya Bharti, along with specialists from AIMS. They strongly oppose the termination. Their argument? The health of both the teenager and the unborn child, with one doctor literally calling it a child-child issue. But on the flip side, look at the Supreme Court's firm stance. They ruled that this decision belongs entirely to the parents and the survivor. It is not up to the state, and it is certainly not up to the doctors to make that choice.
Absolutely, and I really want you to pay close attention to this powerful observation by Justice Bagchi. He said, "Let not medical personnel become the masters of the will of the people. The people would decide." Make a note of this, aspirants. I highly recommend directly quoting this exact line in your mains answers. It perfectly captures the judicial perspective on preventing institutional overreach.
Building on that point, the court essentially put the doctors back into their primary role, which is providing medical and counseling help. The bench made it crystal clear that the state lacks locus standi, meaning they have no legal standing whatsoever to file a review against this decision. That right to review rests solely with the parents or the child. The AIMS doctors are there to medically implement the choice, not to dictate it.
Moving on to Section 3, Addressing Severe Trauma. Now, we have to critically analyze the psychological and human rights dimension of the survivor. This is an incredibly sensitive, essential part of your social justice syllabus. Take a look at this striking quote from Chief Justice Kant. It really encapsulates the burden on the court. He stated, "The law cannot bow to momentary sentiments. The law has to see the whole life ahead for the victim. If law is required to be ruthless, it has to be that." The court's view is clear. Their primary duty is to protect the traumatized child staring right back at them, not to bow to external emotional arguments.
Let's unpack what the Chief Justice meant there. The most crucial takeaway is this observation, that compelling a deeply traumatized 15-year-old to give birth would leave a permanent scar. It's huge. The court is emphatically recognizing a person's fundamental right to live with dignity. And that fundamentally includes the right to be free from continuous, lifelong victimization.
Section 4. Gaps in the MTP Act.
Okay, so having understood the judicial philosophy, we've got to shift our focus to the legislative framework, because this is prime material for your mains examination analysis. Let's break down the current gap in the law. Under the MTP Amendment Act of 2021, the legal abortion limit was increased to 24 weeks for survivors of rape, minors, and women with disabilities. But remember, this specific case involved a 30-week pregnancy. Because of this glaring gap, the Supreme Court is now strongly recommending the complete removal of any time limit entirely for minor rape survivors. They're actually advising amendments not just to the MTP Act, but to the broader penal laws as well.
And just look at the sheer scale of these additional recommendations by the Chief Justice regarding those penal laws. He observed that it should be made completely mandatory to finish trials in these kinds of cases within a week, a single week. Plus, the entire property of the accused should be handed over to the victim. This is the judiciary really pushing hard for systemic, rapid justice.
Finally, Section 5, Mains and Interview Focus.
All right, aspirants, I need your maximum attention for this last bit. Consider this a direct simulation of what you might face in the USPC personality test. I want to leave you with this really provocative question to think about. How exactly should the law balance fetal life with the permanent scar of a minor's trauma?
Use the legal precedents we covered, the quotes from Justice Bagchi and Chief Justice Kant, and those core constitutional principles to construct a balanced, highly analytical answer. Thank you so much for joining us for this explainer, and we wish you the absolute best in your preparation. Keep studying smartly.